That is.
I'm giving those list of dates now. Which are often called the discussion from.
Yes, there were many matters, I believe. This is that matter.
Yes, sir. Yesterday it was supposed to be date. There are actually quite a small list of date. I am giving that.
Oh, the part.
Yes.
You have given that date.
Yes, yes.
Where is the date chart?
That's 2 page list of dates.
इसको अलग से निकाल के रखना चाहिए तो उठा के सब टैग कर देते हो.
I have here. List of date. Like what? List of date call on the. Wait. No, anything. I'm ready to. Sir,
Of cancellation.
Annexure 1.
Annexure.
Annexure 1. Page 50. Cancel it. That's listening.
Yes. Yes. What? What you are holding?
Yeah, Lordship said judgment about our 25 covering the same issue, my Lord, sir. Lordship has held, we thus find that Tahsildar sub-collector is neither competent nor assume the power.
Obviously, that is what it has to go to the mining officer. Let him take a decision there.
One thing.
Facts.
Yes, sir.
I understand that everything has been done in that way, but that has to be corrected by a competent authority. Do you have anything on that the sub-collector is otherwise empowered, even if he has committed wrong?
First thing that the mining officer was not a party to the lease agreement. The sub-collector issued.
Sir, again I'm saying, sir, I'm very interesting. Let us. No, I understood what point you are taking. That once he is not a party to it, he has no authority. I'm just talking. I'm talking. Then I'm giving you a hypothetical example. Lease is executed perfectly. Lease is for a period of say 10 years. Now, in the meantime, the lessor, who was otherwise competent at that point of time, his power ceases and conferred upon the another authority. Suppose if there is any breach thereafter, who is the competent authority to forfeit the lease or to terminate the lease? Is a lessor?
I totally, that is a correct.
Or it is a competent authority at that point of time, because he is now actually a successor in office.
Yes.
So ultimately, you see in the lease deed it says successors, assigns, everything is given.
particularly the mining officer in the hierarchy blood is much below the sub-collector. who is the
Sir, there is no difficulty. There is no difficulty. So then I give you on a civil example. A decree, suppose if it is passed up to the apex court. In an execution stage, section 47 application is filed. It is found that it is a nullity. It's a munsef or a civil judge junior division. Can he not declare that particular decree to be null and void?
What by the Honorable Supreme Court in arbitration?
Oh, sir, there are series of judgments on that. He's talking, that's why I'm giving him an example. Can he not? If a statute has conferred power,
Yes.
he can. He can. There is no difficulty.
But there are some cases, my lords, where statute has conferred, not conferred, and lease has been executed.
No, that is a
Void.
different
That's
issue.
void.
That's a lease itself. The lease itself is void.
Yes.
There's no difficulty in this regard. But
Then the same officer can recall, my lords.
no.
Is the principle.
With ab initio and a voidable contract, there are two different concepts.
120 is speaking of AB papaya.
So, except the
Only in
fraud.
case of a fraud.
Without jurisdiction can also.
No, even that authority cannot.
In-
It can be declared by a competent court.
Yes, 96 Supreme Court line
It's a
jurisdiction.
vertical. But here is a
No, it's not avoidable.
without jurisdiction.
I'm saying that's a void from Kiran Singh's judgment of
Kiran Singh, right.
1954.
Kiran Singh.
I know
Yes.
what it says.
Yes, Kiran Singh. Anyway, here my lords, lease is void.
He will definitely say that all the leases may be cancelled, but not authority who has been
Judgment, my
denuded of power.
lords, Dilip's judgment is covered by everything.
I know.
They will not
That's why.
And Dilip's first I had given.
Yes. The pivotal issue involved in the instant I wanted to say that competent authority may, there is no difficulty, but not he.
Anything else?
Anything so that I can start dictating peacefully.
I'm extremely sorry.
So any of you have anything, so I can
I
start
have
peacefully.
completed since yesterday.
That's it.
Yes.
for 1, 2 and 4.
Write down.
4 months notice had not been issued. 4.
And unexpected is appearing.
I be a lordship want to withdraw your lordship with liberty to lordship liberty may be granted. Okay. Obliged.
Item 5, that was. Item number 6.
Lordships, the moot question in this matter is whether the petitioners, he should have got the benefit under section 8A5 or 8A6 of the MMDR Act. That's the moot question here.
Just first
See-
refresh our memories to
Yeah,
8,
yeah, yeah.
5 and 8, 6. Development Act,
Yes, yes, mine's 1950.
Act of 57.
Yes,
8A,
yes, sir.
8A5.
8A5 or 8A6, that's the.
Yes, fine. Then you say 8.
8A6.
6. Okay. The question is whether it is a captive purpose or it is
Yes.
the use.
And the language is
The language is one and the same.
used.
The only thing is.
Yes, the verb which comes here
There's
is used.
2020 and 2030.
Yes, that's the end
No,
result.
I know.
And the yellow chips, I'm highlighting on that verb is used. I'm highlighting that the crux is used. That means the decision makers or the authority should look at the actual use. Now, your lordships, this particular
Prior to this 2015 amendment, when the query is settled with you, the lease deed must have been executed.
yes, sir.
Does it really indicate or reflective that what would be the mode of user?
Yes, at clause 8 it does.
So if that is the position, then it is it can be accepted from that particular clause. Like what is the mode of user?
Yes, may I just, your lordships, may I just say,
Yes, sir.
may I just say one thing, your lordships? This particular mine was for China clay. Prior to 2015, just before the amendment, this was held to come under the major minerals. Just after this amendment came, in the month of February, it became minor mineral. Your lordships knows that China clay is not something like iron or bauxite. It has small use like your lordships.
Potteries and all many
Yes,
other things.
as in paints, in rubber, as a very small input raw material, it's used. So basically, your lordships, its captive use is to a beneficiation plant. I have been using it as a beneficiation plant. The government has,
What you were doing?
your lordships, I had a beneficiation plant.
What for? What in product?
Your lordship, the end product itself is that way, and that is what is also clarified. That's also clarified, your lordship. That's also clarified. The government does not dispute that my use, whether the very use is captive or not, that does not dispute. And your lordship, I just want to draw because as it fell from your lordship,
That it is not captive.
they dispute on a very different issue. May I just show clause 8, the one which your lordships wanted me to clarify, which will be at page 32 of my original lease deed. That's a part of the original lease deed.
Page
32, clause 8. What was the use for which it was given to me?
Yes.
Clause 8. Liberty and power to enter upon and use a sufficient part of the land to beneficiate any ore produced from the said land and to carry away such beneficiated ore. This is repeated in my all the renewals also.
Sage carry away means removal in that fashion. So it is not coming under the captive.
Now, they say that in this lease deed, somewhere this lease deed should have had a word mentioned that this is a captive lease deed,
Okay.
not a mercantile lease deed. That's what they say. But your lordship should look at section 4 as it stood originally and today. That kind of definition is nowhere there.
No, I understand.
Yes, even Form K, under which this is basically executed under the 1962 rules, that also does not have it. Till date, they don't have it. And the factual finding also of the state government was this, that this person has done nothing apart from using it in his own beneficiation plant, which is, he has 2 plants of his own and 1 in partnerships. In the 2006 rules, where the transition provision came, because of which this section 8A became part of the 2016 rules. Also, that very rule says that beneficiation is a captive use? If I can show those rules, your lordships. That would be the local 2000
2016 rules. which
rules,
one?
your lordships.
Rule.
Two, your lordships, it would be
Minor mineral
Odisha Minor Mineral Concession Rules 2016 2D,
1D.
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 Captive use means use of the entire quantity of minerals extracted from the mining lease in a mineral processing unit or a mineral beneficiation unit owned by the lessee, excluding the minerals of substandard quality or minerals rejected. And that is to be read again with what do you mean by own industry, which will be S. Means and
Not having a 50% at least
Yes.
controlling.
that they don't dispute. What they do is, your lordships, when I come under this in the month of February 2015, I come under the 2016 provision. They immediately, I make a application, give it to me till 30. They said, no, I will give it to you 20. I signed the agreement under protest and also protest thereafter. While I make this protest and I sign, this transitional provision comes.
66.
And then the government says, no, we have to look into the matter. And it goes, the entire committee sits, makes a decision in my favor after analyzing my use and everything, looking at all my account statements. Your lordships, we have to file the annual returns and everything. I can also show them, read the entire thing. Then, your lordships, but came to the department. First, the department passes an unreasoned order. We come to the High Court, it is set aside and said, no, you pass a reasoned order. In second round, without hearing me, they pass an order. Then again, it is set aside. And then again, we go back. And that's how the impugned order today is. If your lordships, may I take your lordships to the impugned order, which would be at page 323, annexure 34.
323.
323, annexure 34. If I can straight take your lordships to the reasoning portion,
Yes.
that would be page 324.
Yes.
Your lordships will see those pointers are there in middle of the page. Yes.
Verification of available.
Yes.
Yes. So they say, and whereas on verification of the available records, the following observations are made by the hearing officer. Original mining lease was granted as a merchant mining lease and has never been a captive mining lease. This is little foreign to the act. During subsequent renewal, this lease was also created as non-captive. Treated as non-captive lease. With regard to the observation of IVC as submitted by IVC, the Internal Verification Committee, which they set up in order to decide the matter. As submitted by the petitioner, it is observed that mere fact that the lease was using the minerals, lessee was using the mineral in his own plant establishment does not qualify them as captive lease. Such a condition has to be specifically laid down in the lease document, and such captive leases are barred from commercial sale of mineral. But they did not refer to that clause 8, which you
Don't understand.
Further, the lessee has the freedom to sell the ore mineral to any individual entity, whether owned by him or not. In the entire original lease document, there is no prohibition on merchant sale of minerals to any third party. Any use of extracted minerals by the lessee for plants owned by him are a matter of choice of the lessee, and such use does not qualify the lease to be created as captive lease. Only on the basis that the mineral extracted from the said mining lease is used by their own plant, the lease cannot be treated as captive lease. And in the instant case, the lease has been renewed under section 8A6 of the MMDR Act and not under section.
Was there any fact finding with regard to the sale of this, I would say, the clay
without beneficiating it, without beneficiating. No, Your Lordship. Rather, it was the opposite. If I can show that. The IBC 271. 271 is serial number 7 where they are deciding my facts. 271. This is the IBC committee report. The case was placed before the IBC in pursuance to government letter dated.
Earlier, this matter was heard by the another bench.
Your Lordship. Yes, Your Lordship. Several times I have tried.
No, I find there are many markings here, so that's why I asked.
Yes, Your Lordship.
Yes, please.
All the members of the internal verification committee examined the aforesaid case thoroughly about use of minerals, that is China clay, raised from the mines by the lessee Prabir Ghosh. The lessee has established a beneficiation plant with a capacity of 24,000 metric ton per annum, situated inside the leasehold area, which has come into operation since 2004. And since then, the lessee has been consuming all the raised minerals from the Jhankarpally China clay mining lease in the said plant. Further, the lessee has also established another beneficiation washing plant in the year 2009, having capacity of so and so situated inside the leasehold area, and has acquired 50% stake as a partner in another China clay beneficiation and washing plant having capacity of so and so in the name and style of White Elephant located outside the lease area in so and so of Sambalpur district established in the year 2016. The above partnership of 50% stake conforms to the description of own industry under Rule 2S of the OMMC Rules 2016. The lessee is presently consuming all in the above three plants.
I read the
And they also made a recommendation
Next page.
in the next page.
Which will examine and it reveals.
Yes.
Now, Your Lordship, the moot question is.
So authority in total disregard to the observation of the IBC. They have proceeded to.
Yes, but the distinction that they are wanting to bring
It's
somehow.
It's a mercantile, these fines, or it is a.
Yes, Your Lordship, we look at section
The
4.
question, according to you, the word captive mine may not be used in the language which is used in the document. Is suggestive of the fact that it is really a captive use, then in that event, mere absence of the word captive use does not take away this
Yes.
uses outside the.
Yes, this is a classic way of how we look at, how we interpret a contract. We don't really go by the name, but we look at the provision. I mean, that's exactly what Your Lordship just helped me out with. That's precisely, I would say. And also I'm saying this, that this kind of a distinction, the statute itself does not provide. Like if Your Lordship look at section 4, the type of activities which any person can do.
Is it historically that the word captive, the word mine, was not to be used in a agreement? If the tenet of the agreement or the language is clear. Then it is for.
The petitioner's admission is clear, sir. That's it.
Admission is clear.
That's it. Kindly turn to page 128. And that is with the
128.
annexure 7.
Yes.
That is the checklist submitted by Prabir Ghosh.
Yes,
And
not name anyhow the petitioner, say that petitioner.
Yes, signed
Yes.
below. That's it. See the middle.
Yes.
Captive, public, non-captive, as per lease deed. He has written non-captive. Thereafter, let's see. Kindly turn to the page 135. 135 Miller. It starts from Roman 2.
Yes.
Not a form signed
The
there.
committee found the lessee to be eligible for extraction and recommends for extension of validity period lease up to 31st 3/2020 under Section 8A6 of MMDR Amendment Act. As the original lease was not for captive use, the extended period is also treated as non-captive under Section 8A6 and not as captive under Section 8A5.
What is this? What is this document?
This document,
What is this document you are referring?
this
Government
document is
Just 1 minute.
starting from page 132, Annexure 8.
What is the minutes of the meeting?
Yes.
The internal department, this is a IDC,
IDC.
not IVC.
No, this IDC.
IDC, that is on 2nd September 2016.
Yes.
Then you ask for a opinion. Former chairman of the NGC.
Yes.
And what is the difference between the IVC? IVC's document came first or this document came first?
This document was first,
These
IDC document is second.
Second. So-
2020.
So why you constituted IVC? IDC was competent. Why you constituted IVC?
Here the recommendation of IBC.
No, these are the internal departmental committee which we wanted. Then why the IBC was there? Subsequently, if this means the positive finding, there was no occasion to go for IBC. And the IBC talks about a different thing. Proceeding on the minute of the internal verification committee, that is on 12/2/2020, and this was held on. This is 2nd September 2016. Sir, after 4 years, you have constituted this. Come to page 132 and 265. The dates are very relevant.
12/2/2020.
That's why I'm saying, so come to page 132, it is the 2nd September 2016. And page 265, it talks about at the top, 12th of February 2020. Much after that. What was the occasion for IVC?
It talks about another meeting.
No. And this was a government letter. The government wanted an IVC. This was your internal meeting. So, which will prevail? And this IVC was constituted by virtue of a government letter number 9768, 10/12/2019. The very first. No, this is yours or no?
That's it's two.
Serial number 1 is yours?
No, a lot of people were considered, I was serial number 7.
7.
And your lordship 273 has all the people who were
Serial
present.
number?
I was 7, your lordship, serial number 7.
In 273.
I know at page 273, your
This
lordship.
was on, this was placed on 31st of December 2019 by a government letter 10461.
And the constitution of the committee is also, your lordship, very heavy, your lordship. All the important officers are involved. 273.
And at the first paragraph, at page 271, it is
Yes.
observed, the lessee has established a beneficiation plan, This is
What?
not, yes, this is
Where,
not
the first language, where from you are reading?
page 271.
Yes,
The lessee has established,
I do not find the
1, 2, 3, 4th line.
The middle.
Middle.
Mr.
Fourth line.
Bhatti, when you are
I'm
placing,
sorry.
you should know, is a 4th line after the 7th or 5th.
Yes, 4th
The
line.
lessee established
The lessee has established a
in
beneficiation-
2004,
Yes.
then he has established in 2009, and then in 2016.
This beneficiation plan, this is only a washing plant, This is not for captive use. And we have stated it's non-captive use. If it is non-captive use, then
Got, that's once he has treated the lease as non-captive, he cannot resign from his stand and say it is a captive.
okay.
This is what you want to
Yes.
say.
And my lord, if it is non-captive, my lord, my humble submission is that, my lord, then it will come under 8A6, my lord, not 8A5. They
So
want,
2020 is the last date.
yes, my lord.
2020 is the last year.
Yes, my lord.
If it is under 5 or
Five.
6,
If it is 6,
Six
then
is
6 and
2020.
30.
Then if it is 5, then the 30, my lord. Now, my lord,
That's what
they are
I'm saying.
developing their case, my lord, by taking the request to an amendment, my lord. Let's say kindly see, my lord.
When he submitted that document prior to 2016 or prior to 2020. This you were referring that
That
document.
document is not mine.
Oh, at page 128.
Yes, that's a government document, their own internal check.
No, they say that you have something.
Yes, my lord. And that is his signature.
No, that's because Mr. gave us some.
It is submitted on 2/8/2016, my lord.
No, that's the
At
signature
page
of the
131.
designated officer, not me.
No, my lord.
Below the signature, your lordship, because in our office, every filing, we make the client also sign it. We make them sign every document. That is why the signature.
What? What, sir? This is the for filing of the.
Yes, your lordship, I make the client,
No, no.
we make the client sign it.
No, page 131, sir. It is a continuance. It's a continuation of the document.
Yes,
131.
yes.
Who has signed, sir?
It is our officer.
Then it is you. And very interesting,
Yes.
sir, Mr. Tripathi.
Yeah.
Come to page 128.
My lord,
If it is non-captive, please consider.
Yes.
Then why under the bracket suggestion was given under 8A5? 8A5 relates to captive.
yes.
Then why you say that 8A5?
It has been suggested to place the case for the IDC for consideration of extension of the lease period up to 31st/3/2030 under section 8A5 of the amended act. As
Why?
against-
If it is a non-captive, then 2020 is the last date. Why 2030?
It was sent for
No,
to be-
you are also coming to that. Because beneficiations, all the minerals in his own beneficiation, plant raised from him, he consumes.
now it is sent to the committee, my lord. And at page 135, that is the
And the committee opined differently. IBC, it sent to IBC. Sorry,
IDC.
therefore
IDC.
IDC, but thereafter government said IBC.
My lord, at IBC opined at page 135, it is non-captive.
Huh? IBC.
No,
It's a IDC opined.
IDC.
But why subsequent there to IBC was given? Why?
Subsequently, IBC has not observed any contrary to this.
What are you talking about? It talks about the opinion taken by the former judge of the High Court, who was a former chairman of the NGP. And he was of the opinion that it is a captive and you do it.
Both IVC and Captain have. They don't.
Last paragraph of the report, I am not going to name the judge that is written. opinion has been expressed. The person giving an opinion is not an authority to take a decision, to extend the lease. He simply said that on these findings, the government may take, means the government will take into consideration the setbacks. And these are the documents. I am really surprised with this, when this was signed, which you are referring at 128. This was in the month of August. And immediately within a period of 1 month, this meeting of the IDC took place on 2nd of September. And they did not take note of this. The observation below that clause 8 or 7, what is this? Clause 7. They did not. Very interesting. You are referring the word non-captive. First thing is you are referring that it is their document. I think you have not correctly read it. It was not their document. It was your, which you prepared. And very interesting. If you are treated as a non-captive, how below it a remark will come and treat this as A5, which is a captive? Why? What is remark? Either non-captive is wrong or a remark is wrong. Either of these two situations.
If my lord, the lease deed executed in 1966 to
Sir, clause 8 is a very, I would say, in that term, is suggestive of both the situations. Carry out or carry taken out. What is the word?
Only beneficiated or can be taken up.
Taken out. Taken out, you treat it as the non-captive. Because the beneficiation plant means that whatever they will extract will use.
No, my lord.
Not to sell outside. In that form.
My lord, in the original lease agreement, my lord, there is no whisper about this captive.
So there is no whisper about non-captive. Both. Tell me that there is a whisper about non-captive. No.
It's not.
There is no whisper about that. Now it is what the conduct of the parties or how they are treated is to be considered.
Yes.
And it appears from the fact-finding authorities that they were using what they were extracting in their beneficiation plant. That is what.
And the mercantile transaction that you have brought is absolutely foreign.
Where is the document?
Look, paste.
Can you show a single invoice that they have sold it in that form to a third party? Was there any material?
That is similar to the observation made by the authorities. Very similar. They have stated in the repetition miller. There is an amendment in 2015 in the MMDR Act. And by virtue of that amendment, miller, this China claim is no longer a major miller. Miller, their submission is that miller, as it is no longer a major miller, it is minor miller. It comes under OMMC rule 2016 or 2004. That on that basis they need extension. If it is so, it is to be extended up to maximum 5 years. Miller.
No.
If it is to be considered in that way, Miller, it can only be extended for the maximum period of 5 years. Miller. Now, that is their case. Now it is no longer a major business. It comes under OMMC rule. If it comes under OMMC rule, then rule 27 Miller.
Now,
Rule
we
66
have
answers
to
it.
look at the language of the provision.
Rule 66, transitionary provision.
Language of the provision. Does it talk about, is it not a mining lease for the minerals? Whether major or minor? It is a mining lease of a mineral,
Yes.
correct? Other than the coal, lignite and atomic mineral, not coming under these three categories. So once there is no distinction which is drawn, if we have got the benefit there and again why? It is restricted only to a major mineral, not a minor mineral?
Section 14 equal lordship
Your
mechanism.
Lordship,
Section 14 of the act.
This is what I really wanted.
Your Lordship, rule 66.
No, let us see.
Section 14.
14 says,
Oh, 5 to 13 will not apply.
Yes,
yes.
will not apply that.
Thank you for that.
but your Lordship
Yes,
will
it will
see
not apply.
rule 66.
Oh. But correct, I'm saying that you are correct.
Your Lordship will see rule 66.
14 will remain. Yes,
Rule 66, which makes this provision applicable
66.
of the 2016 rules, transitory provision which I was
16.
6 of the OMMC rules 2016.
No, why is this challenge? Till now 66.
No. In fact, many people have got the benefit also under this. That's why if your Lordship will see mine is serial number 7. A lot of people have worked out. A lot of things have happened under this provision.
It's very.
The answer is that the preamble of the rules itself, OMMC rule. The OMMC rule, this rule has been framed with exercise of the power conferred under section 15 of the act. So that the rule will prevail of the act.
I'm surprised. You are saying that's why I asked after reading it and asked this question.
Yes.
But your Lordship, the state government by incorporation has decided legislatively to which extent it has power to do.
Oh, the law, what is it?
Your Lordships, your Lordships, they know what the Mother Act, your Lordships, excuse me, what the Mother Act says is this, that it applies only to, the benefit applies to major minerals. That this provision, it will not apply to minor minerals. But your Lordships, by way of incorporation, this very provision now today is part and the benefit is extended. The benefit, your Lordships will try to understand that this is.
When a parent act says that a particular provision will not apply to a minor mineral by virtue of a subordinate legislation, the government will make a particular provision to apply to
Your Lordships,
minor
benefits,
mineral.
your Lordships will.
It talks about simpliciter 8A.
Your Lordships
It does
will.
not talk about
may I-
any other thing.
May I explain, your Lordships?
It talks about eight
Your
A
Lordship, if you-
in
if-
the rules.
Yeah, if your Lordships, if your Lordships, if your.
It does not talk about in that.
I'll clarify your Lordship.
It says eight A will apply.
Your Lordships, your Lordships will.
Anyhow, they have not, nobody has come to challenge
Your
this.
Lordships,
Mr. Anyhow, do not want to make any comment on that. Into that aspect. 266.
Now, the last extension, was given to him on 7/12/2016. And this rule came on 14/12/2016.
yes.
Last extension was given to, last extension deed was executed before commencement of this.
So, will you not take an advantage?
And so far the definitions in the rule is concerned, regarding the captive and non-captive. My humble submission is that, that may not be applicable.
Huh? What?
Because at that time, this specific definition was provided in the
Please kindly consider when a shelter is taken in under the provision of a newly inserted rules of the act. And seeing that I am entitled under this provision of the SEDA, then the definition will not be taken into account.
that will be taken.
He's not really claiming a right independent or opposed to the provision. He says my right accrues on the basis of this new law. And you say that the definition given in the new law will not apply. What are you
That will be
talking about?
that will apply.
So,
I am about to say,
sir, it's a question of a subjective satisfaction and the intention. And the intention is to be gathered from these various terms and conditions embodied in the lease and the other documents, how it is being perceived. If somebody has perceived in a particular manner, even if there is a possibility of another interpretation, if you cannot rule out that interpretation, then why the court will interfere with that? Please work on it more clearly, because the facial expression of his wrath is very deceptive. So go deep into the matter and tell us if anything is omitted or escaped from our notice. Yes. It appears that something is very important there which you have not noticed from her expression. We wanted to just find out that. That's
Well, I had an answer for what he was saying is that Mohindra Singh Gill was my answer.
no, that's true. Doesn't give I know.
Was my answer, because that's not the reason on which they have.
On facts, tell me
That she may take up this matter on Tuesday.
any judgment which has interpreted.
That she may take up this matter on Tuesday.
That's right. Given these things, you cannot approve it and reprove it.
By this time that I could.
MS Gill is very, very, very much there. Oh, we will also go through it. Don't worry. We also have.
Yeah, Lachis,
This
may I-
for order.
may I just
Next
give you
Tuesday, keep it for order from next Tuesday. I will.
No,
give
Your
a-
Lordship, we have given a written date chart and everything with every page number. We also little correct.
B has been rejected without ascertaining any reason, my lord. Serial number 1 is the petitioner, my lord. Rejected technical reason non-responsive.
Yes, how can it be, Mr. Swine?
No, sir,
You have to
rejected.
find a reason. Have you communicated to the reason?
Reason for communication.
Where is that? So what
I got
document that
the
you have?
instruction, it was placed before the committee has decided to leave.
Where is the communication made to him?
We'll communicate that, but I was.
What communicate?
I have to obtain instruction whether it is
That
communicated.
you have not.
But there is something.
How the financial bid? What is the position of the financial bid?
Bid has been accepted, opposite part number 4 bid has been accepted now in the meantime.
Any LOI is awarded?
That instruction I have to obtain, the present position. But I have got the instruction that
It is a right to know the reasons.
we'll communicate.
If you cannot communicate it, then we are going to stay. Otherwise, you know.
So keep it to next week in the meantime. Of the instruction.
The only point involved in the instant repetition
challenging the tender from notice under annexation 5 the running page 1 time period.
So lease was subsisting till 2028.
Yes, sir.
How it can be noted within the currency of the lease
Without any notice,
without
any
cancelling
information.
anything, without cancelling anything.
College notice.
Notice to everyone. IA
Minor.
has it been what is the stage of the tender?
Now I am continue. I was continuing.
What is the stage of a tender dated 19?
It has not been finalized.
It's not finalized.
Finalized.
Where you have stated?
Minor. And I have filed immediately after the list was. The tender was 19/6/2026. I filed the writ application 22/6, Your Lordship. But the list was late.
No, the petitioner has assailed
You are continuing, no?
Well,
Yes.
They should continue.
Item number 3.
Wait, please look. Because I was awarded the date after weeks.
It's fine.
Give it to me.
2nd September.
Because I was awarded a contract for fabrication.
Just
Also, 2 weeks, 1 week we got.
Item number 4.
My clear to sir. Your lordship, we participate in the.
Just 1 minute. In a very, very amicable way.
Yes, ma'am.
Obviously, he is not declared as a successful.
Yes, sir.
Whatever the EMD and all, everything is deposited, he should.
Yes, ma'am.
And it's a six.
Yes, ma'am.
Problem is that one of his account, that is closed.
Close.
Now he is communicating to you the another account.
Well,
Remit that account.
Yes, ma'am.
With an undertaking from MD.
Yes, madam. And in fact, even in a similar matter,
Similar-
my lord has already directed.
Annexure six.
The direction at
And
Annexure
it's a
6.
6, similar
Sure.
order, 6, at page 65, your lordship, similar order, your lordship,
Same order can be
same
passed.
order. If your lordship, 65 page.
The same.
Yes, sir.
Same order can be passed only minutes,
Yes.
2 weeks time maybe.
2 weeks time.
Item 5.
2 weeks is given.
Which
Item
is
5.
given, I'm saying a little more time. 4 weeks.
Not 2 weeks is enough. You are using up his money.
I also same. your lordship.
Item 5.
Item 5.
Yes, I point to matters.
Item number 6.
That's item 6 is also a tender.
Huh?
Item 6 is also a tender matter.
I know.
Yes.
Just one.
That he is not depositing that money.
Whatever.
Your lordship may see that, Malaj. If he doesn't deposit within 15 days time, Malaj, I am to be considered.
Let them say whether deposited or not deposited.
Yes,
How
Malaj.
you
That
say not
your
deposited.
lordship may.
Notice will go.
Notice will.
Notice will go.
Positive.
Bhubaneswar
PMC,
Municipal.
Malaj, is there.
PMC.
Notice it.
Notice.
Fine.
Returnable after 3 weeks. Given.
Malaj, may I just pray, Malaj, in the meanwhile, if agreement has not been executed, let that. Wait.
Item number 7.
Wait. Your lordship, take one shot at.
Enter which was floated, my lord, I have. That has been cancelled.
Which one? The
Tender.
present one. The present one has been cancelled.
Yes, no.
So then no substitute.
Your lordship, we are challenging prayer number 2.
What?
Is,
We have a-
Prayer number 2. What is that? Challenging prayer
We are
number.
not challenging your lordship. We are praying for the tender to include us.
Second prayer.
Yes, your lordship.
Second prayer.
Yes. Second form. They already they have.
Consequential tender for notice is already.
No. They have already cancelled it. So
Like
what remained?
I've given a copy.
we're requesting to be included in the L1 figures in the
No,
next
sir, that can't, can we go and create a contract for you? Can a court create a contract for the parties? Which is between the parties. You can't. Yes. The primary state.
That's not even 1 day to notice. Let's may see let's may see the facts and now they are floating fresh tender. Let's within 6 days. Let's may see. Let's may kindly.
There is a lapse on your part. You are taking show cause was issued. You gave a reply. You said that you should be given an opportunity of hearing before they embark their journey on that.
No, that is not the case, my case is I had to employ 14 members. Out of that, I employed 7. May see page 120 for a moment, Annexure 7, page 120. It's a clear case of abuse, it's a textbook case of abuse,
3 weeks.
In the meantime, no fresh tender. May kindly see page 120.
Item 9.
On mere apprehension, it will not be.
They have terminated in 8 days. My agreement is for 2 years,
We will see if application was in.
Agreement says 30 days notice, then 24 hours notice. The bus stand has also not started yet.
Yes,
Item 9.
Let's let it come with the fresh admission category, so that it can.
Time your lordships, otherwise we are ready, your lordship. There is one document which I think should have been there on record. If this can come next Wednesday, I'll be. It's a blacklisting matter without natural justice, but.
Item note 10.
Yes, my lord, the technical bid has been rejected. Tender for notice under Annex 1 for supply of installation of DC fiber, chest holder and
It not found as per the table.
I have submitted all the relevant
Document where you have.
Lordship may kindly see Annex 2, page 22. Serial number 5. NM Management Services. 18 May 26. Rejected technical. Document not found as per tender. This is the noting they have given. But which document I have not submitted, that is not mentioned. But thereafter I inquired into the matter. Paragraph 7 I have stated that the petitioner met the deputy manager complaint opposite partner 4 and came to know that the OEM authorization letter and a proof of authorized dealership was not submitted under the eligibility criteria, particularly point numbers 4 and 13. The tender required submission of OEM authorization letter and a proof of authorization dealership. That I have already submitted under Annex 3, your lordship may kindly see. Prior to issuance of tender notice, I have obtained that authorization letter. Annex 3, page 23. And thereafter, I have also submitted a representation before the opposite partner 4 under Annex 4.
Not in a position to look at the documents number, nothing. I am unable to go to the document which were referring. The page number is not carrying, nothing is of that kind.
Page 22.
Sir, page 22 is the document which, what you have said, these are the inspection, test, rejection, 7.1, 2, 7.3, 4, what? This is the page 22, sir. Where is the document, sir?
Page 22.
Inspection test.
This is the page 22, sir. I am holding. Which document you are referring, sir?
Inspection test and rejection.
Yes.
So where are the documents? I just wanted to know. He says not submitted. This is the narration.
Narration.
These are the narrations. He is referring a document. Where is the document you have obtained prior to this? Where is that document?
What is that document about? You are telling about the terms and conditions. Probably. And that is part of that.
Yes, ma'am. I rejection of my technical bit. I have annexed as Annex 2, my lord.
And
Yes. At page 22.
At page
22.
no,
What you are referring? Which clause you are referring? Tell us.
Annex 2 is page 30.
Sir, I'm giving you my copies, the page 22 when you are referring, sir, I'm getting this. Tell me, sir, I'm getting this top, page 22.
Sorry. Yes, 30. In my, I. Yes, 30.
Yeah.
Serial number 5. Technical bid has been rejected. Serial number 5.
So it's document not found.
Document not found as per tender.
True.
But I have submitted all the documents. And which document I have not submitted, for that I inquired into the matter because the opposite partner 4 and para 7 I have stated that being aggrieved, the petitioner made the deputy manager compared opposite partner 4 and came to know that the OEM authorization letter, paragraph 7, being aggrieved, the
OEM authorization letter and the proof of authorized dealership was not submitted.
yes, under the eligibility criteria.
criteria, particularly point number 4 and 13.
Yes.
Then
But I have submitted that and I have also annexed that as Annex 3, that document. Before floating the tender.
OEM authorization.
Yes. Annex 3, dated
What
23
is this
2026. Manufacturer's authorization letter.
OEM. What it stands for?
Original equipment manufacturing, sir. Original equipment manufacturing.
Manufacturing.
I have submitted all the documents. Thereafter, I have also submitted representation under Annex 4, dated 4th June 2026. And the previous notice.
What about the second one, the 13? You said 2.
Other requirements.
Other requirements, I have already,
What?
all other requirements are as per the tender notice, eligibility criteria, page 16, the nursing may kindly see.
Where is 13? Okay.
Eligibility criteria, page
16.
Yes, I got page 18 of the tender document. There.
fine.
Yeah.
Yes, okay.
We have,
13 is a copy of the manufacturing license.
yes,
Authorized dealer or distributor license.
under Annex 3, I have annexed that. Annex 3,
That is where OEM authorization.
page 31.
That is the OEM authorization.
Yes.
Sir. And where is this 13 copy of the manufacturing license? Where is the license?
That is the manufacturer.
Or authorized dealer or distribution license?
That is the authorized dealer has manufacturer's authorization letter.
Was it submitted?
Yes.
It was submitted because I'm on behalf of the caveat to the opposite party number 4.
So then how can you?
Your Lordship, I'll just explain. Your Lordship may have a look at the contents of Annexure 3 for once. What we exactly sought for was that an authorization prove that they are the authorized dealers, Millets. The content.
No.
I'll just place.
Why you have placed it in a 3 different manners?
Millets.
You come.
Millets.
What is the importance of the word slash being used after every expressions of the words? What is the meaning? What is the purpose?
So either, Millets, even if
That
you're
shows
not
disjunctive in nature.
Millets, even if your Lordship assumes it. Even if your Lordship assumes it to be an or, they do not meet that requirements.
Why? It
Your
says
Lordship
that he must give a copy of the manufacturing license
My lords,
or a copy of the authorized dealer
my lords,
as an authorized dealer or a distributor license?
my lords.
He is an authorized dealer.
The contents of Annexure 3 do not reveal either of those three conditions. That is exactly
He is
what
not
I'm
a dealer.
My lords,
According to you, he is not a dealer.
my lords. And Annexure 3 only gives them an authorization to file the tender, my lords. It has never been stated that they are the authorized dealer or the manufacturer.
Distributor or-
My lords, exactly. That is the sole reason we have rejected it, my lords. It's a vague Annexure 3, my lords. In any consonants, we could not interpret it to mean any of those conditions, my lords.
I got you.
My lords.
You also may kindly see page 18, point number 4, as per the eligibility criteria. The bidders must be original equipment
Sir,
manufacturer
where
or
is a document of an authorized distributor or a dealer?
the
He wanted that you should ideally say that this company will say that he's my authorized distributor, he's my authorized dealer. I am authorizing him to bid for on my behalf.
yes.
Where is a dealer word or a distributor word that is coming? That is what he says. You are authorized by the company, there is no difficulty.
This is the authorization letter.
Please read it from where I will get it that you are a distributor or a dealer. Tell us from one sentence.
Do hereby authorized to measures.
Bid.
To what? To submit a bid.
Bid.
Yes.
As what? Means as an authorized representative of the manufacturer. But it has to be filed by a manufacturer. Submit the bid means what? On behalf of the company. But not as a dealer or a distributor.
Yes, this is the company. He has given the
Has this company participated in the tender?
That company has given me authorization to participate in the bid.
No. What is the meaning of the word to submit a bid?
He has authorized me. The company authorized me to submit the bid.
Are you aware of a principal and the agent principle? You are simply acting as an agent of the principal, but should be in the name of a principal.
And he has also given that authorization letter to the OMFED, the bidder. The Lordship can see to the Department of OMFED, Bhubaneswar. That letter he has authorizing me, he has.
Nowhere they have said. See the language. They have never said that it is on behalf of the company.
No.
Serial number 4, it has been clearly stated. The authorization letter submitted should
Yes.
not be
Come.
less than 2 years old.
The bid submitted by the petitioner
11.
What two are it?
One for stay of annexation 9 and another is opposition.
What's for?
Stay opposition of annexation 9. And another.
Annexation 9.
And
Another.
And another is of adding opposite part number 4. Successful bidding.
so on that basis, the court will grant an entry order.
No, no, no.
What is the case?
Kindly this matter will be taken up next week along with
Item 12.
See that you want an adjournment.
No, the petition.
This has to go to the executive municipality.
Yes, sir.
What is this? What is the stage of the tender?
Tender, my lord, already final.
Already been finalized, awarded.
Yes, ma'am.
No entry order at this notice 2 weeks.
Published.
Item 13.
I came across some more documents to which I want to file. So let the matter be taken up.
After 2 weeks.
In next.
will be recorded for OP number 5.
Item 14. Item 14.
No. See,
But if he has not participated,
no, he says that he participated.
no, he has not participated. No. The technical bit,
Business protocol.
Item 15.
Cancel, what is there? What are the tender?
Proceed, it's now the present status, I don't know, it's because there is shortage of participants means it was cancelled.
That cannot be, madam, under the OPWD code, it's go for it. It's not a single bidder. Yes.
Which one?
It is a more than one.
Yes,
If more than one, we do not take a decision there.
they will.
for opening finance.
If we are taking a decision, then in every case, you can whimsically go on that.
This might not come under OPWD code managed.
Why?
This is by,
This is under the different Yojana,
yes, Manoj.
so PWD code not.
I know.
Then you can whimsically do whatever you want.
Manoj, at page number 28, Manoj, you've given reasons why we have done it.
Only 2 bidders, he
Yes,
says that you could have proceeded on that basis.
That was the decision by the tender committee, Manoj. They wanted
So
to call
there
for.
is some rationality, reasonability in that regard. The person has already disclosed and you visualize, you have already opened the financial bid.
Yes, Manoj, that-
Then the next time when the tender is floated, what will happen? Do you know the nepotism and the favoritism that will come in this regard? If you find that only 2% is technically qualified, you do not have to open the financial bid. Cancel it at that stage.
No, Manoj, financial bids were not open.
Is
Manoj.
open, not open.
No, Manoj, after technical.
Five persons are, they have participated in the tender process, 2 qualified, and instead of opening the financial bid, they cancelled. And because,
So what is the difficulty?
as per
The
code,
price is not known.
No, Manoj.
and here, your shift, now your shift come to page 29.
Do one thing,
return the financial bid documents in a sealed cover to the return. Both the bids. Sealed covers
Let's have to take in, it should be in the sealed cover, my lords.
should be.
My lords.
The
Continue.
Sir,
I
you
know.
have not been adjust.
Regarding new tender, putting up new tender.
There is no. Yes, ma'am. Who's there?
Second was 16.
The allegation that the petitioner has not been able to execute the work in terms of the work order. There is no so-called notice. Who's for the, let's say, corporation. And both the questions have already been answered by your lordship in the paragraph 12. Paragraph 12, page 11. The lordship has taken note of in the very recent decision, taken note of all the judgments.
Avoid the initial
With partner.
Where is the order of?
Annexure 1, page 12. Page 22.
To 17 millions. I was assigned to the contract millions. From the contract million, there were disputes. Then then award was passed. Now I'm seeking my settlement has already been done by Vivase Biswas. I'm seeking my original bank and they're not released. I already settled under the Vivase Biswas scheme.
What about the award?
Award is settled under the Vivase Biswas scheme. Government of India has to.
You are executing an award.
Yes.
What is the nature of the award?
It's an arbitral award.
I know it's an award, it's an arbitral award, I understand.
Yes.
I just wanted what is the nature? What is the relief which is granted in the award?
Money, decree for money, the payment of money and release of bank guarantee. Two parts.
Now you have come for release of the bank guarantee.
Yes, Milords. Why, Milords?
For this job of CORAM.
Yes, Milords.
We
After
have
that,
gone for execution.
very.
36.
Milords, I'll just to that, my answer is they after my award was pronounced, they formulated a scheme, Vivad Se Biswas scheme, Government of India, where the parties will decide, okay, we don't want to dispute, I will take certain percentage and I will leave. That has also been accepted. They have accepted that 65% will be paid. And they after that.
Going for execution.
No, I have withdrawn my execution. They have withdrawn the section 34. Only on the basis of that settlement I withdrawn.
Section 34.
No section 34, no execution as of now.
It was subsequent to the award.
Yes.
It's a settlement which is the
Yes. Annexure 16 Milords missing.
going for the party.
My lord, kindly be permitted to appear through virtual mode. I am appearing for 1, 2, and 4, your lordship. That is the
Sir,
excuse.
sir, why you have settled it? Will you not honor your commitment, sir?
Exactly, that should not have been, my lordship. It has come first time. Let me take instruction.
Come in the
That-
next week. Next
Lordship,
week you release
10
that
days.
amount.
10 days, if your lordship may kindly. 10
Yes,
days, my lordship.
after fortnight, let them come.
Lordship, deeply obliged.
Yes. Give a date. 19th, it will come. Next,
Best, obliged.
on the prayer of the learned advocate for the Union of India. 19th.
18. Structured in this.
Just 1 minute. You wanted to resile from that participation? Tell me first. You wanted to resile from the participation? You wanted everything back? You will not. How much time they have extended money? By what time?
Lordship, 3 times they are extended, Lordship, without any clarity.
Who is for the this is relating to
Lordship,
National Highway Logistic. Serve the notice and come back after 2 weeks.
Lordship. No, 19.
He has quoted the price. Just 1 minute. Single bed
One of the gross minutes.
and other,
But single bid minutes is one report earliest directed that
and he has awarded a contract for 6 zones.
Yes, minutes.
Huh?
Document says maximum of 3 zones can be granted, and for other 3 zones, other.
Been already been done, work has been awarded.
But can you break for one more difficult, subject to minutes convenience, but I'll not push minutes. But award has been done, but the only difficulty is that now they're breaking the structures, minutes. But
Come.
interim protection is there.
Yes, nothing. Come.
19th August.
If
Item now 20.
You wanted a serious.
I like gathered application.
Yes.
I like gathered application, we might not be accepted. Copy will be short.
Ray, but now once he is appearing, then will you not serve him a copy? So serve him a copy.
Let me have it. Or let me have this handed tomorrow.
What?
This is a short issue involved, my lord.
Anyhow, rejection is on uploading. You take instruction, come tomorrow. Oh, he's appearing. Let him come with the instruction. Tomorrow, come with the instruction.
It's the agreement to execute. Take it.
Whatever, you come. Everything when you have taken, come tomorrow.
Item 21.
Record his name that he appears and submit. Oh, it is not. Yes. Why are we not paying? Who is appearing? Oh, is what is a notice on the CMC? Come back.
Item 22.
Them. 22, same.
Same. Arranging it was same in action.
2 weeks. Next.
Item 23.
Requisites in course of this week.
I mean, permitted to withdraw your lordship.
23. Give. Withdrawn.
Item now 24.
Technical glitch.
Actually, in this case, the petitioner has got the release.
Has got the relief. What?
None for the bank. None.
Instruction regarding this technical bit. I took instruction, you are actually there was technical. We advise them that cancel the patient.
Even if it's not.
What to do? Who is a petitioner? What is his name?
Yes, not.
Huh? No. This item number?
24.
24. Amit Kumar Nath. Who is he? PK Sahu. What do you mean? Dismiss for default. Keep it. Not appear.
None for the bank.
Record your appearance.
Mr. Pani. Item number 25.
Yes, for restoration of periods, I granted a leave of stone query.
Restoration means extension or restoration?
I don't know.
So what do you want?
Extension.
That's why you say restoration. I was really confused with that.
Extension.
Made a representation. Then how can we grant?
We will approach.
You approach.
First thing is that we can't. Without a representation, we can't. We'll have to make a demand justice.
By
You can, but this was where they have already approached, say that the period which was lost, not because of the act of the query holder, but by some other forces, where we say 64. But here you have not approached the authority. What they will do? You'll have to approach them first. Thereafter, we can pass an order. Otherwise, we can't. Withdraw
Yes,
after making a.
before the petition, the representation was not made. After filing the representation, since the lease period expired in between, we approached.
Where is that?
Pending.
There is nothing on record.
Where are we finding?
It's not on.
So what we can do? Adjourn for 2 weeks.
Item 26.
Seeking permission, my lord, to appear online.
56 minutes.
Just 1 minute.
Yeah.
Where is our judgment?
I'm filing my response. State has filed a response. I am filing my response to you.
Where is our judgment? Where is our judgment? There is a judgment which we have.
Yes, my lord, I have been
in the
told,
court.
but I have been told, but I'm so sorry, my lord, I could not locate that.
There
I'll
is
find it
that
out.
we have said the 2 digit after the decimal. We have already indicated more than 5. Then it will be.
In fact, that is an interim order.
Interim order. Yes. We have already said actually what is.
But the,
I've short copy of my system.
but the bone of contention is 17.2, my lord. In fact, in this context, my lord would miss, my lord, 14.
What the mathematical formula or a mathematical precision that talks about? Can you go for indefinite or indefinite numbers, numerical numbers after the decimal?
They are comparing that 14.99%. From where they bring this 14.99% once it is not there in the tender condition itself.
No, it is there. They talk about the clause 17.2.
17.2.
Instruction to the bidder with clause 36 of the OPWD code, where you show us which page, 17.2.
OPWD code, my lord, page 248.
No, you talk about clause 17.2.
Yes,
Yes, yes,
75.
Page
75, my lord.
75.
75.
My lord. Well, interesting reading, my lord. My lord would read all three lines. It should be less than 15%, but while quoting only 2 points.
No, 17 point, yes. If the rate
17.2.
quoted is less than 15% put to the tender, then such will be rejected and tender shall be finalized basing on the merit. But if it is more, one bid is quoted, decimal up to 2 numbers will be taken for all practical. Either
It
at
has
the
same
estimate.
implication. It has same implication. 14.9% is
Same
written.
thing, sir. It is 2 decimal. It cannot go beyond that.
This is not a percentage contract, but your lordship may kindly see. Here,
Then why you have incorporated 17.2?
17.2 speaks about the 15% if 3 persons scored 14.99, which you
Then you will go how lottery system.
But lottery system provided if 3 persons scored the same price. Here, what has happened? For the private respondent,
He is saying that the person whom you have chosen actually quoted a 15%, which invites the rejection.
But his quotation exactly is 14.9 times 9 and 8.
No, that is why it works out to be a 14.999999998.
Yes, Lord. So this should be restricted at 14.99 only. If we read second line, if we read of 17.2.
So in that event, it is there 14.99. How can you go beyond the third numerical number after the decimal?
Unfortunately, they are only reading the first line that it should be less than 15%. Okay, let it be less than 15%. But while quoting the bid, you cannot have any figure more than 14.99. If the figure is 14 point triple time nines, then it will be considered as only 14.99. This is what line 2 is indicating. Lord.
Yes. Mr. Das.
If your lordship may kindly counter that we have filed. That's not so. What did you say right now? You filed yesterday, so today I am giving the copy. I have also served upon them. Also, my private respondent has also filed because our contract has already been awarded in favor of the private respondent and he has already started executing the work. Well, we have.
No, I am reading at page 11. is SBE. SBE quoted, the petitioner quoted what price?
14.99 my lord exactly. My lord will see on the chart.
Please tell the price. That price.
There are four persons who quoted exactly for 14.99.
No, it is
You are not quoted at 14.
No, that.
It's not 14.99. Percentage no had there.
Para,
This is, para 14 is 4403.
This is the price quoted. Rather than this thing.
no, where I do not find it.
Milos may come to page 256 of the petition. It is there. The financial bid is there.
Page 12, para 14.
Base 12, para 14.
Correct. Where do I get it? The petition.
LG Cons Limited.
Huh?
Balaji LG Cons Limited.
Page 7 of the writ petition, my lord, there is a chart given.
Then who is he? Who is the petitioner?
Petitioner is
Well, SBE Adhya Sagar, my lord, page 7 of writ petition, my lord.
Huh?
Sri
Page 7 of writ petition is a chart, my lord.
Para 14.
I do not know, sir. I am at page 12, but looking at the name of the petitioner,
Yes.
That is
I do not find.
Page 7,
Ayodhya Sagar JV.
page 7 we have indicated the price. Page 7, paragraph 5.
Writ petition, my lord.
That is 14.9. That is. No, Mr. Das, you are referring to a different party.
So Sri Balaji LG Cons.
He is not the petitioner. Petitioner is Sri Balaji, SBE.
Sri SBE.
Ah.
Sri Balaji LG Cons.
Right.
They have
S.
written Ayodhya Sagar, but their joint venture is Patel Engineering Limited. Joint venture. They have participated in that.
So participation is by this SBE,
SBE Ajodhya Sagar.
not Patel Engineering.
No, no.
No, my lord. It is SBE Ayodhya Sagar, a joint venture company.
Two entities come together.
No, I understand.
And the SPV is named SBE Ayodhya Sagar. That is the name of the SPV. The companies are two different companies are there. That is one is Dinesh Chandra Bhalecha and one is this.
No.
So they have named their SPV as SBE Ayodhya Sagar.
But there is only one issue, my lord, that my lord would see on page 7, my lord. Their rate quoted is 14.9 times 9 and 8, and others have quoted the rate of 14.99. Issue comes that whether the requirement is of less than 15% or the requirement is of less than 15% and according to my lord point decimal only, say 0.99. So if we cannot quote anything beyond 2 digits, then their bid is non-responsive. Or at least they should be given the privilege that they have only quoted up to 99%.
What is the meaning of this word? I am unable to comprehend this meaning. If the rate quoted by the bidder is less than 15%
yes, my lord.
of the amount put to tender,
My lord.
then such bid shall be rejected.
Yes, my lord. So if someone has quoted 15%, my lord, then it will be rejected.
No, how do I do not know the English word. Less than 15% means?
Less than 15%, less than the threshold. If 15% is the threshold, the bid must be less than 15%.
No.
So it is a threshold.
No.
What are you talking? It is just reverse.
It's reverse.
It is just reverse.
Sorry, my lord.
If the rate quoted of the bidder is less than 15%, the amount put to tender, then such shall be rejected.
It should not be 15%. Less than is not equal to. Less than cannot be equal to, my lord.
So it means anything which is below 15% price will be rejected.
My lord, yes, my lord, he says that rate quoted.
So if everybody has quoted less than 15%, then
they have not quoted less than
percentage basis. What is happening? Suppose
15% less than the amount put to tender.
I know, suppose the amount, let us example very in a simple way. Suppose the amount put to tender is 100 rupees.
Yes.
15% will work out to be 85 rupees.
Yes.
There's no difficult. 15% means 15 rupees has to be 15.
Yes,
has to be
reduced.
then 85 rupees.
Yes.
Somebody quoted 84.99. Somebody quoted 85.5.
85 point.
That
Why?
will be within limit.
Will be again
That will be within limit.
So will be taken for.
Yes.
No, my lord, 84.55 will not be taken.
Not 84.5, 85.5.
85.5.
Yes, 85.5 will be considered,
Correct.
but 84.5 is non-responsible.
But here everybody is saying 14.99. I am really.
Because we are going negatively.
No, I am just asking. Suppose if it is a 14.99, then.
Then, my lords, the second argument is it's a percentage tender.
Please tell me, suppose say that the amount put to tender, I am quoting a 14.99 less.
My lord,
That means more than 85.
my lord. More than 85, yes, my lord. The moment I quote
Then more
85,
than 85.
if the moment, my lord, I am quoting 85, I am non-responsive because it said less than 15%.
That is my kindly see para 30 of the counter argument. Para 30.
Would be better if my lord would see the technical committee report itself. They are not going on the percentage, they are only taking into account the 15% target, my lord. Whether what is the less than 15%?
Contract, not a percentage contract.
Milord says that interim order, there is a difference between that clause and this clause. That's the only thing.
Lord would also see, my lord, page 28 of their reply. How the technical committee is rendering the findings.
How much is quoted there by the successful bidder?
Lord, 0.1 paisa less than 15%. So they are not even taking note of 99%.
We have indicated.
Where?
Para 30.
How much is quoted by the successful bidder?
So it was 440, 33, 91, 470.05.
Yes.
It is not 440 crore, 33 lakhs, 91,470.05. And 06 is the 50%.
And
what
what
he is
is
doing
quoted
is
by and what is quoted by him? By
That is para 40.
Page 28,
Last
page
10 lines.
28 of the technical committee report. They have given the details of all the bidders.
They have quoted their price. PHC Infratech, Dinesh Chandra, Agarwal, Balaji and Deepak. All three of them, they have quoted.
44,3,909.
Yes.
I'm really confused. Still I'm confused. To be very frank, all of you, either it's my incompetence or otherwise. I can't say anything on that. I will treat it as my incompetence.
So sorry, my lord, that we are not.
The first thing is I am unable to comprehend that what is there. You said that PS, BKM, JV, and he is SB something. So I think the L1, you say that he has quoted 0.01 paisa above the rejection threshold. I understood. He is quoting 4,403,391,470.
Yes, Lord.
And he is quoting 4,403 Oh, 909,
Yes.
516.
And the difference is around 5 lakhs.
5,18,004.
There will be, my lord, 1 point difference will make of 5 lakhs.
It is admitted.
I have 1 lakh because this is 510 crore bid, my lord. 1 point difference will make 5 lakhs.
Okay,
Therefore, Lord,
okay, I got
0.99.
you.
Therefore,
So your
0.99.
contention is that it is not really on a percentage basis, it is on the basis of a
Lowest bidder.
quotation.
Price quotation.
Bid price.
Only percentage will come that in the event the quoted price is
Less.
below 15%, then in that event it is required to be rejected straight away.
My lord. I'll just then draw Lord's attention on 17.2.
I got your point. Yes.
Lord, 17.2 again, my lord, page 75.
Yes, please.
17.2.
Yes.
If the bid rate quoted by the bidder is less than 15% of the amount to the tender, then such bid shall be rejected.
Correct.
So this is the, my lord, in a statement given that if you are at the verge of 15% or equal to 15%, it will be rejected.
Yes.
And the tender shall be finalized basing on merits of the rest bid. Now, my lord, very interesting. But if more than one bid is quoted, decimal up to 2 numbers will be taken for practical purposes. So now this is the statement that while quoting the bid, you must quote your bid up to 2 digits only. Question comes, my lord, the persons at serial number 2, 3, 4, they all have quoted only up to 2 digits. So less than 15% is the criteria to become non-responsive, but you cannot quote anything more than 2 digits. So if something is quoted more than 2 digits, that should not be considered as responsible. So basically there is no difference, my lord. 14.99% was retained. Otherwise there is no purpose of saying that you will not quote anything more than 2 digits. So if my lord would see his bid, it is more than, my lord, more than 2 decimal point, my lord. He has quoted 99999 up to 9 digits. So, my lord, my submission is that by applying principle 2.
My learned friend is attaching this decimal point to this 14.99%. Because lordship, I kindly see para 13. There is also a decimal point. That is the threshold. Threshold, your lordship, may kindly see. 403 391 470.05. That is also up to 2 decimal point. Now, what is the price quoted by the L1?
No, I got your point, sir. Question is not what he is trying to say, that this particular decimal connotes the percentage.
That is what.
You are saying that decimal connotes the paisas.
Yes.
This is what is the difference.
Yes.
They have taken, it connotes a percentage, you say it connotes a paisa. That's all. One has to understand this, interpret.
Lord, had that been the intention, there was no need of referring to percentage, Lord. My only submission is this. If then you should have simply said that yes, lowest bidder who is quoting less than 50% will be successful. Then there is no need of, Lord, referring to the percentage. Lord, nothing is, Lord, written just unwarrantedly. While interpreting, Lord, we have to give meaning to each and every word. If this is the intention, then, Lord, these 2 lines are unwarranted. Then what is the use of quoting 14.9? That you only quote up to 2 decimals. Then my friend's contention is correct.
That's all. That is the only dispute. Let us decide on the basis of 17.2.
That is the only.
That's the only the dispute. Nothing more than that.
That is the only dispute. I go down. Lord.
Whatever.
That is awarded in the pendency of the writ petition, Lord. That is the reason. Leave it upon.
Let us decide.
This is an EPC contract. This is not a rate percentage contract. That this is on term fee basis, and this is an EPC contract. So EPC contract is concerned, it is purely on the bid price. The entire EPC and document we have included.
Where do I get it? That is the EPC contract.
Yes. That is what.
The EPC contract. EPC contract will not help them, my lord. In fact, this whether it is
45. Page 45. Their document. In the revision, they have included.
Oh yes, this is your document, sir. Don't say their document.
They have.
This is your document.
Our document, they have it. Online trader invited to that. So on EPC turnkey basis, including power connectivity.
Where? EPC, yes. EPC means
Engineering, my lord, procurement and
construction.
this does not make any difference, my lord. The contract is of EPC or my lord lump sum or whatever it is.
yes.
The question is irrelevant, my lord. For the nature of contract is irrelevant so far the my lord, the bidding documents are concerned.
Yes. Let us just give it.
And condition 17.2, that was included, we will include the amendment brought to the OPWD code that also we have enclosed. That is that annexure A/7 to the compress. Based on that, this clause has been incorporated into.
Just one thing more. Case 49, it says that you have to place the contract price, not percentage. Case 49 is there. Just for a moment.
No, that is what the price will be quoted. Now, the question is whether this price is to be calculated on a percentage basis or on the basis of the price itself. There is no. So that is what is there. 17.2 talks about percentage. Let us see how it applies.
That's only one thing. Page 257, this circular that they are relying on, that does not put at 14.99. Whereas in works contract in road department, they have put in 14.99. Where from the dispute arises in pillars of the interim order that my learned friend just gave. So here is not there much.
Yes, give it next week.
Item 27.
We have dismissed it for default. One more.
We knew it, but you had to remember.
No, it is not. It is submitted by the counsel for the petitioner that the
Yes, please.
who is appearing?
Item number 27.
Who is appearing? 27 is Vishwaranjan Maharatho. E. Patnaik S. Maharatho. Disqualification, it has already gone. Dismiss for default.
Item number 28.
As item 20 has become practice managed because the work has been executed and payment has also been made. However, Miles, in the last order, your lordship is directed to provide the petitioner with the reasons to reject the technical bid merits. I have been instructed that the reasons have been intimated to the petitioner.
Similarly, the action was possible to give it to the affidavit to the advocate, my lord.
To the advocate and record of the petitioner. I just wanted the communication to be made to the advocate and record. Have you made it?
Petitioner,
Do you act on as per your own whims or your own understanding or on the basis of the order passed by the court? Paragraph 4, please read the order dated 22nd of July. Please read the order. If you do not have the time to read the order, then I think you have the gadgets in front of you as well. Borrowing from the other. Is uploaded or not uploaded? How do you know? There you're looking at it.
It is done.
Hmm.
It is done. It is.
Yes, ma'am.
These are uploaded on net. Running people that.
Yes. As per informed the rejection, the reasons for rejection, minutes, I should have provided the documents, I have it right now with me. Minutes.
Then it requires some more observations to come,
So, my
which was done in earlier matter. Mr. Das was not very happy with that observation. So it requires more observation to come. No, we'll make it. We'll make some more observations.
I make the apology.
No, we'll make. We'll not have to apologize.
So the officials are not at fault, minutes, I should have instructed them clearly. As instead of.
We'll make this observation that how it happens and what is the system which is now working. Orders are passed in the open court. I think my voice is very loud. Everybody hears that what I pass an order.
What happened, I don't know, if I received to apologize for this.
Give a copy. Now what to do, sir? Because now the work has already been executed. Award has been made. Payment have been released. Nothing remains on the basis of this tender.
With that, your lordship will come back next Wednesday. Your lordship.
What for?
Let him talk to him. Because they say that he sent on third. So
No. That is the communication. Now forget about
No,
this.
that is
The
correct.
subsequent event has come into play. They say work has already been executed, everything done, payment made. That bidder has gone merrily.
My lord, what I am submitting, that could be true, and now you cannot put the clock back. There are two columns, my lord, where not submitted is the wording written. But he was saying, his client was saying that we have complied everything therein.
Suppose if we are not disbelieving the version of your client. Suppose he has done it. Then now what? In view of
At
that
least
fact.
tomorrow, my lord, next occasion, because
No.
this person,
In view of that fact, what relief now can be given to the bidder?
practically nothing in this. So, my lord, in future tenders at least, we can suggest something or we can say something or lordship can. So you call it on next Wednesday or we'll simply,
What unnecessarily it will remain pending. There is nothing.
we'll simply withdraw on that day if we are talk to the client and.
Because it's a question of belief and disbelief. We are not going into that aspect. That's all.
I won't also take your lordship to that.
I do not want. So on that basis, just say infractuous, it has to go.
Please, your lordship, please.
I think. Some
That's what happened again. Usually careful, but this time it was a bona fide mistake on my part.
convince my brother.
There are
Convince my
certain things,
brother.
your lordship, may sorry to interrupt. If nothing will happen, I know, my lord, as far as this deed is concerned. Lordship, I grant me 5 days, 1 week.
Convince my brother. Been complied with. Yes.
I apologize, man. That's why I provided a copy to them right away. As the official communications that I've received. As my sincere apology. What happened again?
Convince my brother.
You take everything to yourself.
The copy of the
In this case, probably, development has to be efficient. Kind of annexure one at page 22 to the review order. Well, it is addressed to methods KK engineering. And the next page also is it is also to methods KK engineering. And then page 27 is the agreement. Page 27 is the agreement. There also the name of the contractor is methods KK engineering. Now the cost cycle says that at page 2, this has been filed by methods KK enterprises. So they probably have to amend it. They will amend the.
How the Wakalatnama is executed? KK engineering. Oh, that is a mistake. Is by typing. I mean, we can correct. Wakalatnama it is pointed out by the
I think we last week actually received the counter affidavit, need some time to get instruction.
it is submitted by the learned advocate for the petitioner that he has received the counter. Who is Mr. Bhavani Sankar Panigrahi? What?
The tender has already been cancelled pursuant to the complaint received by various bidders.
This was 44.
And 32.
Lordship, the tender was under challenge.
Just 1 minute.
That's in fact, Lordship, I have already qualified and now they have heard the work. So in fact,
They have already received the benefit.
So now I am the successful bidder, Lordship. Why I challenge the
Mr. Dulai, the learned advocate appearing for the petitioner.
Is also Mr. Dalai?
33 lordship, in fact, last occasion, my learned friend appeared for the state made a statement that I had approached this court and in person's lordship's direction. The work in question has been extended. So that's why lordship directed to tackle both the matters where the stay is operating and the present writ application. So my humble submission, there is no such lordship writ application I have been filed. For us, the statement is not a correct statement. And lordship, here the lordship, my grievance is very simple, lordship. The tender in question where I was the successful bidder and I am operating, in that tender matter, interim order is operating, status quo is still operating, lordship. Now they have come up with the second tender where, lordship, the first bidders have already appeared, including me. But my humble submission, in the previous tender, there was a clause, lordship, if I will perform success, lordship,
Then extension can be given.
can be made, lordship, for 2 years.
So that's a discretion. That's a discretion.
At their discretion.
So can a discretion be considered as a mandatory provision?
They say that they will take, because that's one of the terms of the.
No, they may not. Once they decided to float a fresh tender, that means they are not ready to exercise their discretion.
Submission in twofold, lordship.
Yes.
As lordship submission, there is a stage operating.
We are now eradicating this submission. We are lifting the stay.
Second submission, lordship.
We'll lift
If there
this.
is in terms of the contract, they will pass some order. I don't have any grievance, lordship. They will
No, the
pass-
second matter. Yeah, the second matter is October from 24.
Yes.
Give me a second matter. The second matter is.
Kindly see.
Huh?
I have put it at the-
No, that was earlier. Where is the earlier order? I could not.
It's continuing, lordship.
Where is the interim order?
What is lordship? I have put it to order, lordship.
No, where?
Lordship, can you see order
Just look at it.
28
The order number 1, which says
Order
that
dated 28.
affidavit required in support of the amendments in the meantime. No interim order?
Lordship, kindly come to order dated 15
No, that is what I'm saying.
15 2024. 15 2024, lordship.
15-2.
2024. February, lordship.
No.
Yes, lordship. That is, leave this matter on 7/24.
Oh, parties to maintenance.
With the
Sorry.
lordship.
Paragraph 3.
Parties, sir, maintain status.
This.
Status. And the lordship order dated 2025.
Of
It has
15.
been extended.
No, this is the 15-2. This is the matter within 5 cases. In the meantime, publishing starts.
By itself, half of the matter is not on the court.
What is the subject matter of this so that we can
Now, see, now for the lordship, lordship,
now means
lordship not record the other merits. That's my limited grievance now, lordship. Because lordship, I am operating, lordship. But my humble submission, your lordship, can come to second writ application.
I'm looking at 24 writ petition.
24 lordship now, at best, your lordship said that now the reflex of time, I have already completed my contract. It is infructuous, Lordship. Now it can be said, Lordship, if the Lordship hold that is infructuous, then also they have committed another relic, Lordship. That is, they have tried to Lordship over his course proceeding. When the interim is operating, they have the Lordship courage to come with the second tender. So that is that submission I can make, Lordship. But in this present date application, I have very limited standards. Because you have come up with that condition that you can extend if my performance is good.
No, we are going to dispose of 24.
24, Lordship, I don't have any argument, Lordship.
And then,
Because now by
so interim order goes, it will go.
I have already completed, Lordship, so that's why.
The interim order was beyond your time of.
Now, Lordship, I have enjoyed, Lordship. I have enjoyed because, but they should have some regard to rule of law, Lordship. When the stage operating, they should wait. That is not, I am not.
What is the meaning of the word status quo? Why you have allowed him to continue? What is the meaning of the word status quo? That the thing which exists as on the day when the court passes an order should be maintained. And this was a 15/2/2024. The termination was already done on 29/12/2023. You have permitted him to continue under the terminated order. Status quo you have violated. You have exposed yourself for a contempt. We are going to draw a suo motu contempt.
That is what in
No.
it was expired.
Why you permitted? Take back all the money which you have paid to him. Take back all the money which you have paid. Yes?
They have taken my money, Lordship. I have rendered service to them.
Apple.
No, Lordship. For this tender period, Lordship,
No.
somebody will work. That's why Lordship they have taken decision. During this period, you will execute. I'm operating Lordship. It cannot be Lordship.
Let us.
It's only that period.
Within that four.
Within that.
Yes, what?
That period Lordship.
3 years and
What is extension?
From page 7.
Yes. He has entered into an agreement also. Uri,
No, that period has to be Lordship. If I'm operating,
sir, why you signed an agreement, sir?
it is required under law Lordship.
Huh?
Without an agreement, I can't execute Lordship because this transit period, because they have
No.
They have gone for tender Lordship. They have gone for tender Lordship. It is I am duty bound to execute an agreement Lordship. With that period, somebody will work Lordship. They have authorized me.
Which one?
11th March.
This transit period Lordship. Because
till the tender is
tender is finalized Lordship.
And thereafter, the kindly comes to page 15. He has already sent 2 reminders for further extension. They are not coming further.
Because we have approached this honorable for help Lordship because we are waiting for 2 years.
So you can't execute.
Lordship, because now Lordship.
Once you agreed for 3 months and executed the agreement, and then you have approached the court, and therefore it cannot be done.
Because I am Lordship, I required for 2 years Lordship. That's why Lordship.
No, you can't. Because even a clause says on mutual consent can be maximum 2 years with a break of 1 year each.
Yes.
You cannot do it. You can't go beyond 1 year.
That's why Lordship I am not appearing before them.
No.
I am waiting for a court order. Because they are
No court's order.
They are saying Lordship for come and exit agreement.
No.
I am not doing because I want a Lordship legal sanction.
If they have not agreed, then who is providing the service?
For 3 months, the executed agreement. Agreement was executed on 11th March.
Correct.
Petition was filed. Thereafter, it is not written in the petition.
Correct.
Now, after completion of this stop,
That is 3 months means June. Then
that if will come again and execute another agreement.
no, I understand. Then is he continuing to discharge?
He did come, he said.
You say he is not coming. Then who is providing this service? Housekeeping.
And
Who is providing the service?
That is not providing service. But he is not.
They are continuing.
I am continuing Lordship. I am making statement. And if my friend would say about this agreement, I will say they have taken during the application. During penalty, their Lordship insist me go for this agreement. But I was waiting this honorable court's party.
Oh, no.
And Lordship, see the prayer.
You wanted him to continue till September?
It was
This letter shows for another how many days? 3 months? That means September? Huh? And then what is left till February? Another 5 months? Has he participated therein in the tender?
yes.
I have respected.
Okay.
He analyzed some of the tenants. Like this plan. And you also see the prayer.
What prayer?
For consideration of the representation.
Yes.
Agreement is already executed. There is not.
Anyhow, no, Mr. Pala. You continue till the finalization of the tender.
As I want, he will assure you.
Anyhow.
Definitely.
No, they have already gone. You go there and approach.
No, they have not gone through.
Therefore,
The
the instant writ petition
Item number 34.
Also, this matter was listed on 22nd of July for fresh admission. On that day, your lordship was not inclined to issue a notice. Now it is on urgent. I would just like to press few points which I missed that day. First, to recap of the matter, there was a twin condition which was violated by the petitioner as per the.
Where is the technical bit, that rejection order of 11.6?
11.6.
Page?
Yes, sir. Page 53 of the report. At first, on the rejection of my representation.
So this is a ATC 19.7. Where is there?
Yes, Your Lord.
At what page?
Page 46.
There is 19.7, huh?
The second paragraph. First and second paragraph of page 46.
46.
No,
19.7 in Lordship.
Yes.
19.7, additional clause 7. Oh.
Addition clause 7.
Oh,
That is
yes.
19 dash 7. So page 46.
Yes, so these are the twin conditions.
These are the twin conditions.
Yes,
First
then-
is the 3 financial year.
Correct, you'll have to give.
In one, I have not given. I have not submitted a document for 1 year. These 3 years, 22-23, 23-24, and
Correct.
24-25.
Correct.
Out of 1 year, that is 23-24, the document is not sufficient as per their 19.7.
Correct.
And second was 20% of the performance. On
True.
these 2 grounds, I was
True.
rejected. I made a representation. Then they considered my representation. Out of 2, they accepted impliedly 1 and considered me failure on the part of another. That is 23-24. There is no document to substantiate.
True.
Now for 22-23, what I have submitted is a work order. As per 19.7, there should be a work order, invoice, completion certificate.
No, there is no work order.
There is work order, Your Lordship. We have
Where
submitted a work
is?
order.
Where is?
Notes.
Copies of the relevant contract along with the supply proof.
Page 119.
deriving
Page 119 of my
quantities such as the completion certificate, CRAC, invoices, etc.
Yes, Your Lord.
That's all.
Out of all those documents, what I have submitted is work order. Which is
That's why I'm saying whether it
number
will be
119.
a completion certificate, whether it will be a CRAC or invoices.
Those documents I have not submitted, admitted.
So then what is wrong?
Your Lordship, if there is a 3 documents, one is work order of 1 year, invoices of 2nd year, completion of 3rd year. Which document will be taken into consideration and which year it will be considered and for which year this particular supply is. Now there we have one year prior we have provided all the documents. 1 year subsequent we have provided all the documents. In between I have not submitted. Why this 3 years period is? It says that there should be a continuity.
Absolutely.
Even if I manufacture one piece of sanitary napkin, I am okay with this particular clause. So this work order was there with us for the year 23-24. We have submitted the work order. We are continuously preparing the sanitary napkin, Your Lordship. Our is manufacturing process only for sanitary napkin. We are continuously providing. Now, what is for 20%? Now, Your Lordship last time said financial year cannot be diluted. Now, they have diluted the financial year for the purpose of 20%. If we were strictly going by their interpretation, even we do not comply those 20% for one financial year. If you take the annual year, then only that 20% is okay. they have considered that aspect of mine. But for one aspect, we say that only even if one sanitary napkin is there, I am okay. But that purpose, they are not accepting mine, Your Lordship. That is my only contest.
So that is what is if the terms and conditions embodied,
That's what I said. If
embodied
work order is for
something.
1 year,
No, I understand that you say that preceding 1 year, post 1 year, if there is a there in between the interregnum, it will be presumed that there is a continuity.
yes, one argument is this. And one argument more is this, Your Lordship. If consider a case, my work order is of first year, invoice is of second year, and completion certificate is of third year. Then for which particular year I will be falling for this particular contract? Because not every time the financial year includes all the 3 documents. All the 3 documents will be different. For this case, the March 24 was my work order. In May, I got the invoice. Within 3 years, I got the invoice. Within 3 months, sorry. Within 3 months, I got the invoice. That is my submission, Your Lordship.
Which for the other side?
I'm for the opposite button 1 into
Yes.
What's the first condition is twin condition finance. What we are supposed to do is what is first.
But you have already accepted one.
What?
Now it is confined to another.
Yes.
There were twin conditions.
Yes, ma'am.
One you have already said, yes, we were wrong, we accept your stand. The only the second one.
Rejection order is not attached to the writ petition, my lords. Though it's not in the form of an affidavit, my lord. This is actually the rejection order, my lords. On which ground they have been rejected.
That is an IA we have filed, Your Lordship. Because we filed the writ petition on 20th. We were preparing the writ petition in between this particular order came of 18. We have filed one IA 127
supposed to supply is
Yes, what is it?
relevant contract, my lords, along with supply proof.
No, what is this?
This is a rejection order, my lord.
Which page?
So that's a IA that has been filed. I don't have the copy, my lord. I have supplied a single sheet, my lord. Single sheet of paper, my lords. That
No, this is the rejection order. Yes.
Yes.
Same thing. Yes.
yes,
Yes.
the rejection.
Oh,
order
it's
is
better to read this.
conditions, my lords.
It is better to read this.
Yes, my lord. Certainly, my lord.
This font size is very difficult to
Extremely
read.
sorry, my lord.
Yes, read it.
Yes, my lords. So let me read the first.
Representation submitted by such and such has been examined.
Yes, ma'am. The representative submitted by Vedya Infrastructure.
22,000 has submitted a document. The bidder has further requested.
The bidder has contended that it had executed supplies during the financial year 2023-24 and has submitted documents in support thereof. The bidder has further requested consideration of supplies executed during the subsequent financial year towards fulfillment of the past performance criteria. Upon examinations, it is observed that additional clause 19.7 requires the bidder or its OEM to establish regular manufacture and supply of the tendered item, that's the twin conditions, my lords, and to satisfy the prescribed experience and past performance criteria through documentary evidence submitted along with the bid, my lord. The committee observed that the bidder has relied upon a supply order issued by Jharkhand Medical and Health Infrastructure Development Corporation Limited, hearing reference number so and so, dated 5th of March 2020.
No, I understand that they wanted to supply a further order.
Yes,
Then you took a clause 14 shelter.
Yes, ma'am.
And then says that after it has gone, no additional document shall be entertained.
That's additional clause number 19.14, minus of the tender committee. They cannot file any subsequent documents. That's 19.14 at page number 14.
I do not know. Clause number 14 you have said. Additional clause number 14.
Yes, ma'am. At page number 48 of the paperwork.
Yes.
That you cannot file any subsequent documents.
Oh, I understand.
Yes, ma'am. So what they were required to file is a contract, that's a purchase order, my lord, along with supply proof of such as completion certificate, CRAC or invoices, my lords. The second they have not supplied it. Though in the previous year they have supplied the documents in the financial 2023-24,
yes,
they have not supplied, my lords.
Yes.
Lordship, may kindly see the purchase order which they have annexed. That's a page number 120, my lords, annexure 6. There's a conditional purchase order that's not neither a completion certificate nor any invoices. That will evident that they have supplied it.
Yes. That's all.
I'm not relying upon any other subsequent documents which they have said in the.
No, you are relying on this.
Only the document which I submitted during the bid participation. That is 9119.
There's only the invoice which is submitted, that's right, which is only the.
And the work order has already been issued to the OP7 months in this case.
Yes. Ask the order.
Grateful.
Later. You're responsible. Yes.
With respect to the work order which they have issued to respondent number 8, we have made an amendment of the repetition and brought before as an IA 13402.
Yes, that's all. Yes, next.
Operation.
Item 35.
It is find there is no merit now.
Before your lordship, I submit on the merits of the case, certain applications which have been rendered infructuous, your lordship may dispose them of. IA number 12291 of 2026. This has become infructuous because the bank guarantee has been encashed in the meantime.
I hear that it is submitted by the senior counsel appearing for the petitioner. We got the name that
Not to cancel my tender, they have cancelled it in the meantime. So that has also been rendered infructuous. 12292.
it is same submission is that it is submitted that the instant interlocutory application was taken out seeking the injunction upon the authorities not to cancel the bid or what?
Yeah. Bharat, the difficulty is that they are opening the subsequent tender. Having cancelled my earlier tender on the ground of administrative reasons, they forfeited my bank guarantee. And they have now floated an identical tender.
Earlier tender cancelled and forfeited your bank guarantee?
Yes, Bharat.
How? How it can be done? If you cancel the tender, then how can you invoke the bank guarantee?
That matter.
What?
But in fact, this matter was on the board last Wednesday. So since this court was not available, a motion was made before the alternative bench. The alternative bench took up the one of the matters, not this one, and they have dealt with it. Actually, the application for non-encashing the bank guarantee, and they have passed an order rejecting that application. Well, that order, it was subsequently, when I saw the order, it's initiated by errors apparent on the face of the record. I shall show to your lordship.
Then what to do?
A review has already been filed in that matter.
Yes.
So that will be dealt with separately. Your lordship may...
This is the interlocutory application which is dismissed.
It has been rejected in that case for seeking injunction against the encashment of the bank guarantee. So more than 5 crores have been encashed in the meantime. Well, I was required. In fact, what has happened is, there's a project for laying of pipeline. It was split up into 3 parts. So 3 tenders were floated. I have emerged successful in all the 3 tenders. And by the letter of acceptance issued on a similar date, I was called upon to furnish security, which runs into the extent of about 108 crores. 108 crores. Security alone accounted for rupees 108 crores. So I invoke the provisions under the OGFR, which provides that you can furnish insurance security bond as alternative to bank guarantees. I offered to furnish insurance security bonds. They rejected my representation. Thereafter, what happened? They amended the OPWD code by which insurance security bonds were included.
Included or excluded?
Included. Now, I again wrote to them that in view of this, kindly allow me to furnish insurance security. They did not respond to the same. I submitted insurance security bond. They sat over it for 2 months. Thereafter, on one fine day, they cancelled the tender on administrative grounds. Simultaneously, they issued a letter to the bank to forfeit the bank guarantee. Now, having done this...
No bank guarantee. There is no bank guarantee. Insurance...
No, EMD was given by way of bank guarantee.
Okay.
That alone is about 5 crores, which I had given. So, in 3 cases, it was about 5 crores that was forfeited. Now, having realized that they have committed a mistake, they wrote to the bank. They sent a mail to the bank, which is all there on record, saying that don't encash the bank guarantee. The bank by then had encashed. Now, thereafter, the bank wrote to them that please refund the money which has been remitted to you so that we can restore the bank guarantee. Silence. This is where the matter.
Ooh, what are you doing?
Education department. And the worst part is, Manoj, a tender floated earlier to my tender. When insurance security bond was not there in the picture, in that the successful tenderer has tendered insurance security bond, which has been accepted and they have entered into a contract with the same department. It is there in the record now, by way of amendment.
The copy has already been served to you. They showed the receipt.
Once another copy, I can serve it, but
Give him a copy and keeping this, we will allow this amendment to come. And what is this? If that facts are there, how can you do it? First thing is you yourself realize that you have committed a wrong and then approach the bank that saying that yes, though we wanted to invoke the bank guarantee, don't invoke any further. The bank said, I have already remitted the money. You give it back. Will you not give it back to the bank? Interesting. And now once they say that you have accepted the insurance, despite there is no amendment in the OF, what is this? OGFR. Then in that event, how can you deny instead of bank guarantee? Your purpose is to secure the money so that at least he cannot fly away therefrom. Then you have brought that by way of an amendment.
May I please, your lordship? My lord, I may be permitted to visit since I am suffering from viral fever, so I could not attend. My lord, here is a case, my lord.
Yes, what do you say? I think the other side is saying something.
Yes, sorry.
Going to be resolved. Oh, there is a positive vibe that has come from him.
That is on 10th July. Oh, it's Monday. Highly obliged.
Yes.
Obliged. Highly.
Item number 38.
38 prevails. When up next week, when senior is not well today,
Oh.
all the matters listed under the item 38. Tomorrow, next week.
Next week.
What is the name of your senior?
Mr. Upendra Kumar, senior advocate.
Record that
Senior
he is indisposed and accommodation is sought. Next Wednesday.
Item 39.
Yes, item 39 was with the 3 repetitions. Lord, we have challenged the virus of certain notifications issued by the transport department.
Virus of the notification. Notification. Virus.
I am today, I am seeking some time to prepare a note and if it's put.
Next week.
Item number 40.
Yeah, I'm appearing for number 2 and 3. That was from next week. I will get ready.
Next week on the prayer of opposite party number 2 and 3.
Item 41.
Lord, 40 and your lordship, I prefer Monday, my lord. This is a covered matter of incentive. I will present it Monday.
41 on Monday.
Highly obliged.
41 Monday.
No, Monday. That is. Ajay, you do it next Wednesday. Yes, next.
Item 42.
We do speaking and prayer and adjournment on behalf of senior counsel, Mr. P.K. Ratha, who is engaged in this matter. 2 measures. Is out of session.
Are you opposing the prayer of personal ground of a senior?
Personal ground I am not opposing, but fact is 200 some odd 4 months is under stay.
Next week. Next week, you just keep it.
I have also filed a mistake for vacation of the interim order. Can you take 10 months of recognition so that it can be disposed of? 240 months of life.
Item 43.
Interim order may be
43 months. We have already prepared that affidavit minus and file it by now.
Interim order.
I'm for the
Then 43. 43.
43.
43.
43, sir. Petitioner is.
Okay. Petitioner is not here.
I am for the petitioner, my lord.
What do you want?
For the petitioner, we have filed an affidavit, an additional affidavit and an IA.
I've already sent it. I will get response, madam. So I will be filing it within 10 days so that my can take it.
Then after 4.
Item 44.
Please, your lordship. I have filed an intervenor application, your lordship. IA number 7.
Who is for the petitioner? Oh, Mr. Dalai is for the petitioner. Yes. Intervening application. Serve the copy.
Your Lordship, I didn't get the copy.
Sorry, you have filed an intervening application. You do not have a copy.
Your Lordship, I thought the petition is asking for.
Your copy, madam.
Pardon you.
What is a good name? Recorder name that she appears and submits that she has filed an application.
I'm challenging my lords. Blacklisting orders as page.
What is this modification of the order dated? 13.6.
146 and 147. The first order research F1 and research limited, including proprietor, partners, directors, hereby banned from having business dealings with sale Rourkela Steel Plant for a period of 3 years.
Who are you? You are appearing for the petitioner. Why you want a modification of the order of 13.6? Because it is given you a opportunity to participate.
Not opposite party filed a modification.
Who wanted a modification?
We never wanted to modify.
The IA 185101 has been filed.
We had 5.
What modification you want? That they should not participate in PSU or they should not participate in sale. What?
That's in the essence, it's an application for vacation of the interim order.
Say that.
In essence.
In essence. What is the suppression?
Finally.
Sorry, on what ground?
Because there is an interim order which allows them to operate, to bid in other.
Is it under what provisions? Now I am going in a very civil manner. The order of injunction was passed in your presence. Now once you want a variation, modification under order 39 rule 4, then what are the grounds?
Those are strictly.
What are the grounds? Where is a suppression of fact? Where it will cause an undue enrichment?
Principles only would apply. In the strict sense, those may not apply to rates.
So why not apply? Mutatis mutandis will apply.
Well, that's why I said, in essence, it's vacation. Your Lordship may hear this fine.
Then vacation, you'll have to, on what ground order was passed in your presence? So
it's a banning order. My learned senior, I think, is wanting a final hearing. My Lord may hear this final.
I have a limited point, madam. The order itself is patently without jurisdiction. It has not been passed on twofold. One is that the rules do not permit a banning for 3 years. That is one. Secondly, the work was completed. They levied a minor fine. The entire allegation was this: we were doing the maintenance work of the effluent treatment plant. They had given us the tender, we were the L1 and we did it. Successfully completed the work. Took our final bill. Surety was held back. During that period of the refund of surety, they suddenly came up with a complaint that 5 or 6 or 7 of your employees who have successfully completed the work, they possess fake certificates, university certificates, degrees. So we said, look, we immediately took those employees out of our employment. And we told them, we said, look, it's not possible for us. We have come all the way from Mumbai. We are executing your work. We have done big works for you. We have already been a very successful contractor for you. There are no complaints about our work at all. And then even on record, there is no complaint on the work or quality of the work or completion.
So we said it was not humanly possible for us to, we are employing 100, 200, 300 workers to go to BPUT or to some university and check out the certificate. What we have done, we've done the next best thing, we've taken them out. So, and they levied a fine for that also. We paid the fine. After all that was done, they refunded our money. After the refund of the money, suddenly somebody wisens up and says, then this order emanates, 146 and
No,
147.
show cause was issued.
Yes, those formalities are
Show
completed.
cause, these submissions were not there in the show cause. Those are my seniors' creations.
Very attractive way of introducing your lordship, my lord. And you have a very sweet smile, my younger brother. So I will not. My lord, 146. Then suddenly they ban me in sale. Thereafter, my lord, on 7/5 they ban me in sale. And on the same day, another order comes, bans me in all other subsidiaries of sale. So I come to the High Court, my lord. High Court says, no, you can operate in other this thing. This work you are blacklisted, will subject it to final hearing.
It was not in his hand. If your work was not hampered, if the satisfactory performance is there, everything is there. If some of the employees which they employ, I think they must be a local.
Locals.
So
Travel from Mumbai for
whatever. And immediately when you brought to the notice, they removed them, whatever. Now, you know, the blacklisting order has a very, very larger impact in a commercial world. So once blacklisted, there are many other organizations or the government entities which says that if you have ever been blacklisted, then you'll have to disclose and you may not be permitted.
Actually, madam, that is the prejudice we are being. We are actually.
Now he will blame us that it is what the bench has really taken up this.
I'm not, but
we have gone as per our regulation. My lord,
What is the regulation? I just wanted to. What is the regulation? This is what if there is any dereliction in duties, in discharge of their duties, if there is any dereliction in their performance, if that performance is not satisfactory or something else, I can understand you throw him out. Who can do it?
In the show cause, they have admitted that it's a mistake. And we have to go by our...
No, they are also not denying that, yes, these persons, when you say that they are not having the requisite certificate, they are admitting, yes, they're not. They have not.
We have informed them that we have taken them out.
They have taken, madam, may kindly see their show cause.
And they currently
page 125.
So what's in that very organized?
No, they have an interim order. Now, my lord, may kindly see page 125, their show cause.
Mr. Mukherjee, try to visualize the situation. Had it been a case that the sale has suffered any loss, a single penny, I would have understood. If the facts what he has projected shows that there was not even a single loss of the exchequer. Why?
We have completed for them 150 crores of work in that very organization, sales. Now we are continuing with 16 crores in Durgapur plant and 222 crores in RSP itself. We are continuing there.
So that is okay. That the banning order then doesn't affect new project. It's only for new project. Now this has.
I am again saying that considering the gamut of the entire thing, consider this.
Now our problem is that we can't have equitable considerations.
No.
Then
Then leave it to the court to have the equitable consideration.
No. So my lord,
on the ground of proportionality and a disproportionality, we will consider on that. You may be within but proportionality and disproportionality has to be taken into account.
So my lord, just give me 10 minutes on some other day. I'll just submit on. 10 minutes.
You please go through at least my judgment over there, here also on the ground of proportionality. Subject to my brother is there.
My lord, tomorrow.
What?
Tomorrow, 10 minutes he wants.
Don't Don't get encouraged.
I'm not getting ahead of myself, Malad. I would only
Hey,